It is 9 o'clock on a Tuesday night. You are sitting at your kitchen table. In front of you is a stack of papers. Your I-130 petition, your sponsor letter, your proof of relationship, everything you gathered over months of careful preparation. Your spouse is on the other side of the world right now, waiting. Your children ask every single week when the family will finally be together. And you are staring at the USCIS website, watching your case status say the same 3 words it has said for months. Case was received. No movement, no update, no answer. Your hands are shaking, not because you did something wrong, but because no one has ever told you what is actually happening inside that system. No one has ever explained what the real rules are, what changed in 2026, and most importantly, what you can do right now to protect your petition and keep your family's future on track. That ends today. Because in this video, I am going to break down the actual 2026 I-130 processing changes, including the ones that are genuinely good news for petitioners. And I am going to expose exactly what is causing delays for thousands of families, why most people panic and make mistakes at the worst possible moment, and what the legal steps are that you can take starting tonight to give your case the best possible chance. Stay with me until the very end, because the action plan I am giving you in the second half of this video is the most important part. Now, let me first explain why so many I-130 petitioners are in a state of confusion right now, and why that confusion is costing families months, sometimes years, of unnecessary waiting. The trap that most people fall into begins with a misunderstanding about what the I-130 actually does. Most people, including many people who have been in this process for a long time, believe that once USCIS approves their I-130 petition, their family member can start packing their bags and preparing to travel. They believe approval means arrival is close. But that is one of the most dangerous assumptions you can make in the entire family-based immigration process. And it is the reason why so many families feel blindsided and devastated when months go by after an approval and nothing seems to happen. USCIS is very clear on this, even if they are not loud about it. The I-130 is only the first step. It establishes that a qualifying family relationship exists. It does not guarantee a visa number is available. It does not automatically trigger an interview. And for many family categories, it is just the beginning of a much longer journey. Here is where the danger gets real. Social media is full of people with no credentials, no licenses, no legal training, telling you things like, just refile and your case will move faster, or, if you do not hear back in 6 months, your petition is denied, or worst of all, do not worry about an RFE, just ignore it and wait. Every single one of those statements is wrong. Some of them are not just wrong, they are catastrophic. Ignoring a request for evidence, or RFE, from USCIS is one of the fastest ways to get your petition denied outright. And once a petition is denied, you are not just starting over. You are also dealing with a denial on your immigration record that can complicate every future application you file. Then there is the new 2026 policy reality that too many petitioners are completely unaware of. On January 1, 2026, USCIS issued a formal policy memorandum, an official government document, expanding its guidance on processing holds for nationals from certain countries. This memo, which builds on earlier guidance from December 2025, now applies to individuals who are citizens, nationals, or were born in any one of 39 designated countries. What this means in plain language is that if your beneficiary, the family member you are petitioning for, was born in or is a national of one of those designated countries, USCIS may pause or hold the processing of your petition for enhanced review. USCIS has confirmed this policy exists. It does not mean your case is denied. It does not mean your family member has done anything wrong. But it does mean that the published processing times you see on the USCIS website may not reflect what is actually happening with your specific case. The national median processing time, the number USCIS shows publicly, can look reasonable on the surface while individual cases from certain countries sit untouched for a year or more. That is the trap. The system can make your case look normal from the outside while quietly placing it in a different review lane on the inside. And if you do not know that, you will wait and wait and wait, assuming everything is fine, while the clock runs out on options that could have helped you. Now let me give you the legal shield, the actual law and official policy that protects you and what you are entitled to know and do. First, understand what USCIS is required to tell you. Under the Immigration and Nationality Act, USCIS must provide a written decision on any immigration benefit application. They cannot simply ignore your case forever without consequence. When a case is outside the normal processing time, meaning your receipt date is earlier than USCIS's own published inquiry date for your form type and service center, you have the legal right to submit a formal service request. This is not begging. This is not bothering anyone. This is a right built into the process. USCIS has an official tool for this. It is called the Outside Normal Processing Time Service Request, and you access it through USCIS.gov using your online account. It creates a formal record that you inquired, and USCIS is required to respond. Second, know the difference between your two main timelines. USCIS processing time, how long it takes them to approve your I-130, and visa availability, how long before your family member can actually use that approval to move forward. These are two completely separate clocks. For immediate relatives of U.S. citizens, that means spouses, parents, and unmarried children under 21, there is no annual cap on visa numbers. That is a specific provision of the Immigration and Nationality Act that gives these categories a significant advantage. USCIS confirms that immediate relative petitions are not subject to the numerical limits that cause years-long backlogs in family preference categories. This is genuinely great news if you fall into this group, and it is one of the most important facts to hold on to when the wait feels unbearable. Third, know your concurrent filing option. If your beneficiary is already living in the United States on a valid status, you may have the ability to file your I-130 and your Form I-485, the application to register permanent residence, at the same time. This is called concurrent filing, and USCIS recognizes it as one of the fastest pathways available within the family-based system. Concurrent filers are currently being processed faster than standalone I-130 petitions in consular processing, according to data tracked through USCIS's own processing time tool. If you have not explored whether your situation qualifies for concurrent filing, this is something you should discuss with a qualified immigration attorney this week, not next month. Now let me bust the rumors, because this is the section where I save people from making expensive, life-altering mistakes based on things they saw in a 5-second video on social media. Rumor number 1. My I-130 is taking too long, so it must be in trouble. This is false. USCIS itself says that a long processing time does not automatically mean there is a problem with your case. Processing times fluctuate based on service center workload, the volume of petitions received, and review requirements. A pending case is not a denied case. Rumor number 2. I can pay someone, not a licensed attorney, to call USCIS and get information about my case faster. This is dangerous. Unauthorized practitioners, often called notarios in some communities, are not licensed to practice immigration law. They cannot legally represent you before USCIS. USCIS will not give case-specific information to unlicensed individuals, and people who pay these individuals often end up with fraudulent filings, missing documents, and cases that are far worse than when they started. Rumor number 3. If I refile my I-130, I get a new, faster priority date. This is completely wrong. Your priority date, the date that determines your place in line, is established when USCIS receives your original petition. Refiling does not create a better position. In fact, it starts your wait time over from scratch and wastes your filing fee. Rumor number 4. USCIS online processing times are always accurate for my case. As I explained earlier, the published medians do not reflect individual nationality-based holds or service center transfers. Always use the Processing Times tool at USCIS.gov to compare your specific form type, service center, and receipt date. That comparison, not the headline number, is what actually tells you whether your case is within normal range. Now here is your action plan. These are the exact steps I want you to take, starting tonight. Tonight, go to USCIS.gov and log into your online account. Look up your receipt number and check your current case status. Write down the exact date you received your receipt notice. This is your official filing date, and it is the anchor of every timeline calculation you will ever do on this case. Tomorrow, go to the USCIS Processing Times tool, also at USCIS.gov, and select your specific form type, your relationship category, and your service center. Compare the inquiry date USCIS shows to your receipt date. If your receipt date is earlier than the inquiry date, you are legally within your right to submit an outside normal processing time service request. Do this through your USCIS online account. This week, pull together every major document in your petition package and review it for accuracy. Check every name spelling, every date, and every document against what you originally submitted. If there is an inconsistency, a different spelling of a name on a birth certificate versus what you wrote on the form, or a date error, note it. Inconsistencies are one of the most common triggers for a request for evidence, and catching them now puts you in a better position to respond quickly if you receive one. Also this week, check whether your beneficiary's country of birth is among the 39 countries subject to the January 2026 Enhanced Review Policy. You can find this list by searching for Presidential Proclamation 10949 on the Federal Register website or by searching USCIS's own guidance on processing holds. If your beneficiary is from one of those countries, you need to know this, because it changes the strategy for your case, including whether filing a congressional inquiry or consulting an immigration attorney about a writ of mandamus timeline makes sense. If your case has been pending for more than 12 months beyond the published inquiry date with no movement, no request for evidence, and no explanation, speak to a qualified immigration attorney about your options. A writ of mandamus is a federal legal action that asks a court to order a government agency, in this case USCIS, to make a decision on a case it has been unreasonably delaying. It cannot force an approval, but it can force a decision. And in some delayed cases, it is the action that finally moves the file. Finally, make sure USCIS always has your current address on file. If you have moved since you filed your petition, update your address immediately through your USCIS online account. USCIS sends all notices, including interview appointments and request for evidence notices, to the address of record. A missed notice because of an old address is not USCIS's error under the law. It is yours, and it can lead to automatic denial. My name is James. I am a senior immigration analyst with 6 years of experience, and on Immigration News Today, I do not give you opinions. I give you the survival strategies that keep families together. The information I just shared with you is exactly what immigration law firms charge hundreds of dollars an hour to explain. You got it free today because this community deserves accurate information, not fear and rumors. Immigration rules change overnight. Right now, while you are watching this, policies are being updated, memos are being issued, and deadlines are quietly moving. The only way to stay ahead of it is to stay informed. Join my WhatsApp community for instant alerts before I even post on YouTube. The link is in the description below. I will send you updates the moment something changes that affects your case. If this video helped you, please give it a thumbs up right now. That small action helps USCIS petitioners all over the world find this channel and get the information they need. Share this video with someone who is waiting on an I-130 right now. Your cousin, your neighbor, your friend from church. One share could change everything for a family that is still in the dark. Check the description for links to USCIS.gov, the Processing Times tool, the Federal Register entry for Presidential Proclamation 10949, and the USCIS Service Request portal. If you want accurate, fast, and reliable immigration updates, subscribe to Immigration News Today right now and turn on notifications. Staying informed is no longer optional. It is essential. I am James. Protect your status. Protect your family. I will see you in the next update.